I didn't hit anyone's.
Yeah, thank you.
Sorry.
All right, everyone. Good morning. What do we got? Wednesday, May 7th. Time is moving briskly. A little after 9:30, and we are picking up more work on S23 and act relating to the use of synthetic media in elections. And we had discussed some language changes. Council has provided those. Should be a draft 2.1 on our site. And I know we have some feedback from some other folks who've been tracking this. So let's open with council. How are you doing, sir?
Good morning. Very good afternoon.
Time flies.
Rick Sagel, Office of Legislative Counsel. Yes, you have draft 2.1, and I'm going to share my screen just to throw things off here this morning because I have some other things to show you besides the wonderful draft. I want to thank my colleague Tim Devlin, who was here last time, covered for me. He's going to come here later as well to address any questions about some proposed changes by the AG's office. He's more equipped to discuss those changes with you all. So draft 2.1 actually has no changes from 1.2, except I made it a strike all. I understand Tim told me it was a request to make it a strike all. I still want to go through and show you what is different from the version that passed the Senate, just to kind of refresh our memories here. On page 2 of the draft, there's a little tiny yellow highlight on line 16. That is my way of indicating something was deleted. You can't highlight something that's not there, right? But I, in my style, I highlight the little period there because previously there was a sentence that read, and I quote, and not smaller than the largest font size of other text appearing in the visual media. So if you're looking at the screen, line 1, that sentence, it would say easily readable by the average viewer. And then it said, and not smaller than the largest font size of the other text appearing in the visual media. That line was deleted, mostly because the courts may find that to be too onerous on the part of the distributor or creator of the media. If you can imagine an AI created video, if there's text on that video that has the title of the commercial, whatever it happens to be, the disclaimer would have to be just as big as that. And that could cover the entire screen, right, of the video. So now it is just, it must be in a size that is easily readable by the average viewer. Okay, second change was deleting the following sentence. So we're still on the same line. And the sentence read, if the image or video recording does not include any other text, the disclosure shall appear in a size that is easily readable by the average viewer. That was deleted because the current text is enough. We don't need to. That was a superfluous sentence because of the previous deletion. We do not need that extra sentence, if that makes sense. Yeah. Okay. Third change. On, let's see, section 2032. On page 3, line 8 and 9, we added the phrase commentary of general interest to the exceptions. So this requirement to provide a disclosure shall not apply to a radio or a television broadcasting station, et cetera, that broadcasts deceptive and fraudulent synthetic media as part of a bona fide newscast, news interview, news documentary, commentary of general interest. That was added because in the following subdivision, we also had that same phrase, the commentary of general interest. So there was a desire to have that same exception carried through both exceptions.
As just a refresher as to what that series of words captures.
So look at the other words as well, right? So you're looking at bona fide newscast, news interview, news documentary, commentary of general interest, or on-the-spot coverage of bona fide news. I think that does expand the scope quite a bit from what is news to what could be, maybe more of a not specifically reporting breaking news or the 6 o'clock news. This could just be a weekly show that goes over what happened in your town, in your state. It doesn't have to be specifically what the politics or what happened in today's news. It could be just It broadens the exception quite a bit. I'll say that.
Partisans.
So would this apply, for instance, to like an editorial segment of a news program?
Yes.
Okay.
If that wasn't covered in the previous language, then yes, it would be covered by this addition of the commentary of general interest.
Understood.
And then we have on the next page, what this does not apply to, the exceptions, we added a person that produces or distributes deceptive and fraudulent synthetic media constituting satire or parody. More about that in a second. There's a request to learn more about what that means. And the final change was just changing the section title on the last page, page 5, from the previous was, I think it said injunction. Yeah, now it says enforcement. So you're not changing the actual language of the statute, just the section heading from injunction to enforcement to kind of match what's happening here. So are there any questions about the language in draft 2.1, or shall I move on to the questions that were raised last time when I was not here?
Let's start with door number 1. Any questions at that first phase of his question?
Okay.
Yeah.
So there were 3 requests. Make it a strike all. Check. Number 2 was to understand the current landscape of court cases, other states that have passed similar laws, how courts have handled it. So I think 23 states have passed similar legislation. They're not all exactly like this one. Some are, there's a couple of bans. Minnesota's famously has a ban. Most states require disclosure like Vermont's would. California, they passed this law back in 2020. I don't remember. It's been recently. And their case came out earlier in the year. Coles versus Bonta, I think Bonta is the Attorney General of California. So in this case, district court, lower court, held the law to be probably unconstitutional. And I'm going to highlight a couple of things the court said, which may help you understand why it ruled that way. But I do want to let you know this is a lower court, district court. They get overruled all the time. But it is something to look at and to see what the judge said and maybe things you might want to consider if you want to amend the bill further to make it stronger. So I have a couple of lines highlighted that I think are important. And again, the California law is very similar to Vermont. The one important difference is it also requires a disclosure for parody. So Vermont's does not, right? Vermont's parody is totally excluded. In California, if you made a deep fake election ad that was parody, you had to say this is parody in a font that's easily readable by the average viewer. So the California law does much more, bring the highlighted portion, than punish potential defamatory statements, since the statute does not require actual harm and sanctions any digitally manipulated content that is reasonably likely to harm the electoral prospects of a candidate or elected official. So what I'm referring to in our bill is when you look at on page 1, the definition of deceptive and fraudulent synthetic media, there's not really a crime for harm here, right? It's just that you're injuring either the reputation of a candidate, you're influencing the outcome of elections, or you're otherwise deceiving a voter. Like that's the harm that the Vermont law would try to stop. But you're not saying there's actual harm here. Influence an election is not necessarily harmful, right? And I would argue that isn't the point of a politician who's running trying to win. So aren't they trying to influence the outcome of an election?
Mm-hmm.
So certain things, I don't know. It depends how you read it, but that's how I read it. So maybe the categories of what is deceptive and fraudulent media, maybe we could talk about more if you want to. Moving on, the First Amendment does not permit speech restrictive measures when the state may remedy the problem by implementing or enforcing laws that do not infringe on speech. So this is kind of just a general First Amendment principle that says the government normally should not restrict speech. And this is what this bill does, right? This bill is restricting speech. Even though it's just a disclosure, you're not banning it. You are still requiring a creator or producer of the stuff to alter their video by putting a disclosure. That is still restricting speech. while the court gives weight to the fact that California has a quote compelling interest in protecting free and fair elections, which is what I would agree, the interest must be served by narrowly tailored ends. And I think I've said that phrase to this committee several times. So while you can do things to ensure the election is free and fair, it's got to be very narrowly done. You can't just obviously ban this type of advertising, but can you do something that restricts speech and also do it just finely enough to where you're not overly burdening a person's right to communicate, right? Supreme Court precedent illuminates that while a well-founded fear of a digitally manipulated media landscape may be justified, this fear does not give legislators unbridled license to bulldoze. Excuse me. Sometimes judges get pretty interesting with their language, to bulldoze over the longstanding tradition of critique, parody, and satire protected by the First Amendment. Reminder, this law required a disclosure for parody, which this one is not. And this court did not like that aspect of the bill. The safe harbor carve-outs, meaning the disclosure requirements, attempt to implement labeling requirements, which, if narrowly tailored enough, that's a really clear line there, could pass constitutional muster. But because the California bill encompasses a broad range of election content, meaning the injury of the candidate influencing the outcome of the election and so forth, that would be protected even if false and cannot stand First Amendment scrutiny. So this case, it may be appealed. I think actually it's going to be appealed, and maybe California wins. However, the district court makes it clear that they think, at least on initial view, it's problematic, right? And Vermont is stronger, I think. I think it is stronger constitutionally, but potentially there are things to be improved upon. So that's the first case, California. Second case, my former home state, Texas, had a law as well that actually banned the stuff. And this is back in 2024. They ruled it unconstitutional. Okay, same thing as California. This is the Texas statute, or at least the part that they cared about. A person commits an offense if with intent to injure a candidate or influence the result of an election. That sounds familiar, right? The person knowingly represents in a campaign communication that the communication emanates from a source other than its true source, basically a deepfake. We do not disagree that government's interest in protecting the election process may be of sufficient importance. You hear that all the time. States should be allowed to regulate election integrity, okay? We agree with the Court of Appeals that this Texas statute encompasses communications that are not arguably false or misleading and is not narrowly tailored to achieve the interests advanced by the state. Given that influencing elections is the essence of political speech, it is difficult to imagine what speech would not be included under the statute, including neutral statements, vote in the primary election this Saturday, and true statements. If you are wondering whether or not you should vote in the presidential election, the state of California has more registered voters than any other state. So would those statements be made to influence the outcome of an election? I would say yes. Under Vermont's definition, that would also be potentially deceptive media if made with AI, right? So that's why I think maybe we need to think about the definition. Because you're lumping in a bunch of stuff that, again, politicians use all the time because you want people to vote for you.
I'm sorry, could you just read those two examples again?
Yeah, the one on the screen?
Yeah.
Sorry, my head's walking it.
No worries. I can't read it anyway. I have terrible eyes.
Okay, vote in the primary election this Saturday.
Yeah.
What if that's false, right? So that would be protected speech, though. Lies are still protected speech. And you're not defaming anybody. If you are wondering whether or not you should vote in the presidential election, the state of California has more registered voters than any other state. So that's a true statement. But is that used to influence an election? Possibly, right? Are you trying to scare people to vote in the primary and so forth? This language is too broad and encompasses too many statements that have the potential to influence the democratic process. A citizen should not have to rely on the sense of humor, kindness, or leniency of prosecutors when discussing or sharing opinions and messages regarding governmental affairs. I think there may be one. So again, the Texas law banned it. All right, that's not what Vermont's doing. Texas was going to totally ban it, but I do think it includes some interesting language about how far you can go even with just requiring a disclosure like Vermont's law does. Okay, the last case, this is the Minnesota law, which bans this similar type of advertising. This is the most recent case, January 10th, 2025. This one is interesting, okay, because one of the plaintiffs was actually a representative that voted for the bill. So the representative votes for the bill, banning deepfakes, and then that's she, I believe, yeah, Mary Franson. Then she doesn't realize what it does, which none of you would ever, right? You would understand what you're voting for. I mean that seriously, Mr. Chair. So she realizes what's happening and she gets mad because, oh, now I can't make these ads that would potentially be banned by the state. Oh, I also voted for this. Uh-oh. So she and this other guy, Coles, you may recognize, same plaintiff as in California. He apparently is big on Twitter, X. He makes a lot of these ads, the fake parody ads. So he's like going state to state suing to try to get an injunction on the law. Long story short, this case, because neither party had standing, the case was dismissed. But I had this case pulled up for another reason. I want to tell you the story about the representative that passed the bill, but then hated it and then sued. And the court didn't like that. The court said you've literally had the chance to stop it and you didn't because you voted for it. I thought that was interesting. But the main reason I want this case is because they do say that at some point when somebody does have standing, when somebody is prosecuted, then you can sue. Then you can say this law is unconstitutional, whatever, and then they'll get to it. But this court did discuss parody, which is my last kind of topic I want to get to. And parody is a difficult one to talk about because parody is protected by the First Amendment. And this Vermont bill specifically excludes parody and satire, which I think is good. And I think it's good that, and when I say good, I mean, like, I'm thinking about the law being constitutional. I don't mean I like it, right? So the fact that the Vermont law specifically excludes parody, does not require disclosure, I think is safe for the law. However, parody and satire are already protected by the First Amendment. And you see the portion highlighted, parody is that which cannot reasonably be interpreted as stating actual facts about an individual. So if you think about political cartoons, right, those are protected. Even if it's a drawing of President Biden, President Trump, Elon Musk, it is protected because it's a parody. We all know it's not real. With AI, it's different, right? I think the whole point of this is to disclose when somebody makes an AI ad that tricks us into thinking this, did President Trump actually say this? Did President Biden actually say this? I don't know. So then you have a disclosure saying this is not real. So a parody piece, if it has the word "this is a parody," is that a parody? Maybe, maybe not. This Coles guy, this plaintiff, he always apparently on his videos, I haven't watched them, but apparently he says this is a parody on all his videos. And that makes it safer for him, but you don't have to do that, right? Political cartoons don't say this is parody. The Onion doesn't say this is parody. Maybe that people, apparently there's a subreddit for people that read The Onion and think it's real. They take screenshots of people that are responding to Onion articles, which is satire, right? But The Onion is protected speech because it's satire. There are several of these newspapers that, produce fake news, literal fake news. So my answer to what is parody is the courts do struggle with that. And it has to be, and the law, I think the way it's written, that a reasonable person cannot tell it's not that they're reporting, I think it's okay. Like, I don't think there's much else you could do to protect parody and satire besides excluding it and making it clear that it is not part of the law. So I wish I could give you a better definition and more examples, but
I'm kind of going back to like on this parody piece that I said this the other day, right? Like if you're doing, like cartoons in the New Yorker or like, Far Side would even like lampoon, like, delve into like some political whatever. It's a drawing. Right? You know that, right? It's pretty obvious. But with AI, it's creating these likenesses that are, almost unrecognizable as false. So that's the part where I'm struggling with how to speak to within the structure of this language, how to speak to parody, right? I mean, Onion, are they even using, I'm just like speaking, right? Like, are they even using AI to generate any of their content?
Photoshop, at least, if you look at if you look at The Onion, what they produce,
Yeah.
sometimes it looks real.
Yeah.
The pictures look real, but obviously, if you see The Onion, you know, hopefully that it's not real.
But we're like trained for that over time as like consumers of, content, right? Rep Artisans.
I don't want to interrupt you.
No, I was cutting myself off.
I know, there's a lot to think about. All right, I have a few questions. The first one is, the way that it's written right now is, it's limiting, it's putting a time frame around it, right?
90 days.
Right, so if I were to, it's 90 days in either direction
No, before.
before, okay, so like the day after the election, I can make 47 AI videos saying that the president said this, or you know what I mean, like, and that's fine. But then 8 months from then, or 9 months from then, all of a sudden, if I'm gonna distribute again, I need to add something to it saying that this is AI generated, right?
That's kind of the box.
Right. So my question for you, as far as making it constitutional or not, does putting a limit on, like, does adding that time frame help? It does help.
Yes.
Okay.
And you could make it less if you want to make it stronger, I don't know how much difference it makes,
Okay.
but yes, it's definitely stronger than no time limit whatsoever.
Okay. And then I have more questions, but I don't want to. And then, so in my mind, when we're talking about this, I'm equating it in some way with, which I know it's not the same, but when we are running for office and we have those disclosures because that's the only thing I can think of, that we have to put on a campaign ad, or we have to we paid for it, I got a sign and all that stuff. Would you equate that to this in some way, even though it's like a campaign, like, is there overlap between the campaign laws and is this could it be considered the same thing? Because it's not unconstitutional to say to us, you have to put on a flyer that says Shea Waters Evans is the worst. If you're going to mail it out to people, you have to say, I paid for it, or like.
So it is in a way, because it is it's regulating speech. It's similar in that way. Because you're saying that if you used your money to produce this ad from your account, then you must say paid for by Shea Water, everyone, whatever it is, right?
Yeah.
So yeah, in that way it is required. As far as it's also a content, and not to get too in the weeds here, but it is a content-based regulation, which is also a red flag. When you require certain people and certain things to be regulated, like in this case, we're regulating election speech, right? Which is a red flag. Like, why shouldn't it apply to everybody or every type of speech? It's applied just to, deceptive media that is injuring a candidate, outcome of election. That is content-based regulation. That's a red flag. So yes, to answer your question, it is similar. And, I think it's also probably less of a burden because it's just the candidate. Here you're talking about the entire country of people that have to abide by this law. In your case, it's just if you're running for office and you have an account, then you have to abide by it. Here, it's everybody. If you create media that's deceptive, you have to do disclosure. And you may not know that this is the law, right? Doesn't mean that you won't be fined if you are ignorant. But as a candidate, you're probably aware. And I would hope that you have to do those things.
I forgot.
Rep Nugent?
I've always understood that regulating speech, it's like time, place, and manner.
One of the regulations that the courts look at, yeah.
It's is putting a disclaimer, would that fall under manner or that would be falling under content?
So yeah, there are a few exceptions to your freedom of speech. They're very small. One is that the government can regulate the time, place, and manner. So curfews, right? Like that's a thing that sometimes local municipalities will issue a curfew for protests. You have to be inside by 8 p.m. because of violent protests. So, but it can't be. It's got to be a reasonable regulation on that type of speech. So this would be, yes, a time, place, and manner regulation. But I think again the question is it narrowly tailored enough to get the government's legitimate interest, which is election integrity, right?
So if we're talking about, I feel like what we're trying to accomplish here is preventing people from from influencing an election by tricking or deceiving someone, right? There are laws about that relate to things that aren't elections, right?
Are you asking me to give you an example of that?
If you
So-
have one, but I'm assuming that there's,
I mean, so you have the right to lie, right? That's kind of my general statement. You don't have the right to defame somebody. And that could be considered a trick, I guess. You can't say someone is a liar or someone, it's got to be more specific than that. You cannot hurt the reputation of somebody with a false statement, right? That's kind of what defamation is. And it can be written or spoken, right? So, but other than that, politicians can be that you have a wide lane to convince people to vote for you, right? You can say things that maybe aren't true. And that's protected speech. So I'm trying to keep it to this context, but I can't think of any outside this context where trickery or lying would be unprotected speech, meaning it would be protected.
well, like, what if I call you and I say I'm from the IRS and I need your social security number and your bank account? That's.
Not okay.
And I would give it to you. Yeah, right away. Yes, whenever you're
Just trying to
grabbing.
figure it out.
Yeah. No, it's a fair,
But I mean,
right, right.
That's something that we're not allowed to do, right? Because we're,
right. So you're impersonating.
yes,
Right, so there's usually something underlying besides the speech. So you're impersonating. I don't know. I got a colleague here, a friend that may be able to chime in with more examples. But I think the impersonation of a police officer or IRS agent could be a crime in and of itself, not false pretenses. We have an attorney general here as well. Fraud.
Defrauding or
Okay.
tricking someone to obtain property or services, making false statements to government agencies and defamation. And lying under oath, obviously.
Forging a check, yeah. So there's those kinds of things, but they're not usually speech. That's I think where I'm getting tripped up is I'm thinking about speech, and there's really not a lot that is. And you had a good example of impersonating somebody and
Yeah.
defrauding somebody based on that, but there's that underlying thing you're doing just wrong. Not the speech itself necessarily. It's the
right, and the thing that's wrong here would be trying to influence the outcome of the election.
Oh. Right. And the other example I'll give you that I just thought about this is commercial speech can be regulated a bit more strictly. So, lawyers can't say we're the best lawyer in Vermont. There's advertising. If you sell bottled water, you can't advertise it as the amazing cure for cancer. There's certain things when you advertise.
Truth of advertising.
Right. There's things that are more regulated in that context, but again, it's not normal speech. That's different. It's advertising. And that's tricking consumers in a way that maybe you shouldn't be able to because of X reason, right? Sorry?
Incitement.
Incitement. So if you incite violence,
Unlawful action or something like that
So
in your speech, I mean, that's been.
but it's got to be there is an incitement exception, but it's got to be your speech must lead to imminent harm. It's got to be let's go burn down the courthouse.
Detrimental outcome.
Yeah. It's more than just riling up a crowd. It's let's go do this horrible thing right now.
Yeah.
Let's go back to Perry. No,
It's mud.
yeah.
Yeah.
Then there's two that are currently in litigation, but most of them are not. So, take that for what it's worth. Can you make the bill stronger? Probably. Constitutionally, probably. But there's not a clear roadmap. You can do certain things to improve it, but
Any questions for Rick? Just
I know, it's a lot.
it's the opportunity to think out loud, Colonel.
I question whether you should even be looking to move this bill forward. Testimony I'm hearing. That's just,
Yeah, no, I appreciate
am
the thought,
John.
yeah.
Akron is my humble opinion. I'm a little wary of what I'm hearing.
On which just the broader, just sort of freedom of speech component.
Constitutionality, all that raises the hair on the back of my neck when I hear those kind of things.
I think
Sometimes again, my opinion only, sometimes not we collectively. Things I've seen in the past don't weigh that heavily enough, just in my opinion. Again, my personal opinion, I'm one of 180.
I appreciate that. And I mean, we're kind of, I totally understand what you're saying. But one of the pieces of me where I've been really intent on trying to figure something out with this is, it's just such like an unregulated area and this technology is moving so fast that I think it would be wise for us to at least try and get our foot in the door with some form of statute that kind of starts to rein it in.
Yeah,
With a fear of consequence in some way, shape, or form.
I understand that sentiment. I would just not a huge fan of jumping and then go, oh crap, I forgot my parachute.
No. I hear you. I hear you.
And, a little feel free. Here's where I think we're at. I think we get the parachute on. We got the straps on the shoulders. We forgot to do the leggings. And if we get violently thrown out of the plane enough, the straps can come off. We can get a parachute.
I appreciate the analogy.
I've been on airplanes and I know that would be very bad.
Oh, that's why we're noodling on the language and having this conversation. So, anything else for council before we shift over to AG's office? Nugent.
Hand up as well.
Oh, I got a hand up. Okay, we're gonna go Nugent and we're gonna go Hooper of the hand.
I guess I would be curious if you had thoughts about that. Like about like if we have all the things that Representative Morgan wants when we jump out of the plane.
We have all the straps to it.
Yeah.
We have all the things we need before we jump out of the plane. So what the like in general, it's a very slippery slope, right? When you start regulating speech, it's just very tough to thread the needle without, having the court come in and mess it up. I think, but I don't know, like, I don't know. I have three court decisions to look at, really two that pulled the issues with it. And I think if you maybe improve the definition of what is deceptive and fraudulent synthetic media, if you narrow it a little bit, because right now it's just so broad, like deceiving a voter, like that's, again, I think sometimes part of being a politician, you want to get a voter to vote for you. And what does deceive mean? Does deceive mean lie? Not necessarily, which is protected speech anyway, to influence the outcome of an election. That to me is like what you're trying to do. You're trying to win the election, right? So with intent to injure the reputation of a candidate, that's defamation. That makes sense. That's already, not allowed. I don't know, maybe you can think of something else. And that would be something that what are you trying to stop? You're trying to stop a person defrauding the electorate, right? By lying and saying something that is just demonstrably not true. So how do you word that? I can think of something, and I have 10 here as well, but I think there's maybe ways to improve that definition. I think that, and maybe 90 days is too much. Maybe make it 60, I don't know. The primaries included in this, so think about that too. You have the general election, and it would include town meeting. It would include any election would be part of this 90-day limit. So maybe 60 days makes more sense. Excluding parodies, I think, is smart. But that's for what my 2 cents for what it's worth.
Okay. Thank you for the change. Representative Hooper.
Howdy, committee. Would you all like to see me? Full disclosure, I'm not wearing a tie. I don't know if that matters to you, but I can keep my camera off if that's your preference.
Whatever you're comfortable with, sir.
Okay.
The
all right,
attire is of no consequence to me.
Oh, good. Okay. Rick, good morning. I'm curious. You said 3 or 2 different court cases are in progress. Which ones?
Yeah. So you have the Coles versus Bonta in California, and then you have, which is very similar to Vermont's law, and then you have the Texas case, which was a state case. That one was also decided a couple years ago. There is a third case, the Minnesota case, but that was not really a full ruling on the actual law itself.
Okay. Well, I think it seems to me like demonstrably was the key word I just heard in your last answer, and I'm curious if we could get a more robust definition of that component to the policy, whatever it might look like. Also, I want to know more about false advertisement and the parameters around that. I have a real issue with the notion that people, particularly politicians, having the right to lie. I don't feel that the Constitution protects lying as a form of free speech. I feel very strongly that that's something that we should try and refine the definition of. It doesn't sit well. If you asked most voters, do you voter believe that the people who represent you in government have a right to deceive you? I think that you would almost always get a very strong and clear no, that's not something I believe, but I'm not sure. Other than my editorializing, let's see, the notion that cartoons are obviously parody, that seems like it's probably still true, but I don't know. I mean, it seems very flimsy to think that parody is defined as things that cannot reasonably be interpreted as real information, or however that seems very ambiguous. So I guess I'm not sure that I agree with Representative Morgan that we shouldn't do anything at all, but I do get the feeling that if California, Texas, and Minnesota are all sort of pending litigation, why wouldn't we wait to see sort of what that looks like? I guess my question then, Rick, is how soon do you suppose we might hear about those cases? Any forecast on that? I know that's maybe an unreasonable question.
No, Rick, it's not unreasonable. These are pretty recent decisions, and I quite honestly don't know if the appeals have already been filed. I imagine they have been. But I would imagine not by the end of session, would you hear an answer? And again, also keep in mind, if the appeals court says something, then it may get appealed again to, in some cases, the U.S. Supreme Court, which may or may not chime in, or it could go back down to the district court for more fact finding. So unfortunately, I don't know, but you have an assistant AG here who might be able to tell you kind of what she thinks the litigation would look like if it happened here, and maybe ways to strengthen the bill in their way too, which would be helpful, I think, to you all to hear. But I can come back with false advertising definitions, and I can come back. Yeah, and I can come back with a updated, deceptive, and fraudulent synthetic media definition, which I would try to find maybe threading the needle better if you all want that.
No, I think yes, more information the better, and I think that's a great segue to Leslie from the AG's office. Unless anyone has any more questions for Mr. Sale.
Oh, okay. Thank you.
Cool. I knew this was going to be a fun conversation at the very least. Good morning.
My name is Leslie Welts, I'm Assistant Attorney General at Attorney General's office. I think this is my third time testifying this session with you all, and you're the only committee I've testified before, so thank you for hosts. I'm also
House.
yeah, we're all admin law nerds. So I'm also the chair of the Campaign Finance Committee that's in the AG's office, and that group investigates and prosecutes not just alleged violations of campaign finance law, but also alleged violations of Title 17, Chapter 35, which is where this language would be positioned. That is for those of you familiar with the chapter name, it's something about offenses against the purity of elections. So it's a kind of an exciting title for a statute. So I'm here today to talk about enforcement policy and of course, any other questions that you have, but maybe first I'd be happy to answer how I would see the litigation unfolding of this bill, if that's
I think that
okay. It sounds like it was a question.
yes.
So not being the Solicitor General or the Civil Chief, I'm not an authority on that, but my understanding of how this would go is that if it's a question of US constitutionality, it would go to the federal district court. A challenge of this law, this bill, would be filed in the US District Court for the District of Vermont to be heard by the federal judge because it's a federal question about constitutionality. And the outcome of that would be appealable to the Second Circuit Court of Appeals. And then after that, pending that decision, that could be, you could ask the US Supreme Court to hear an appeal of that, and they may or may not take it up. And if the US Supreme Court says, no, we're not going to take this, then that means the decision of the Second Circuit stands. If they take it, of course, their decision would be the law of the land. So these other cases that are working their way through the district court may or may not be taken up by the US Supreme Court. At that point, what they have to say would be useful. But these things are not super fast. They're done pretty slowly. So that's my understanding of the process that would unfold. If there are any questions on that, I can. Okay.
Oh, yeah. Oh, wrapped up.
This is actually off the top a little bit probably, but if we had to defend this law in court, what does it cost Vermonters to defend the law in court and then say we lose?
Oh, so fact specific. I don't think I could opine on that, but you're right. There's always a cost. So we have to think about that. But I can't give you an estimate on that. Apologies.
All right. Mhm.
Yeah, I'm sure it was very resource heavy to do so. Yes. You know, and then that kind of, I mean, some people will counterpoint that being like, you know, it's already attorneys that are paid for by, you know, the state or, you know, federal, but it's the resource being diverted to this as opposed to another
Mhm.
case.
I'm just curious.
It's, I mean, that question gets asked a lot, but it's really hard to like actually hone in like even like a reasonably ballpark, right? I mean, I've asked that question to myself many, many times.
And to the extent, I mean, whatever issues are being raised in that challenge will necessitate whether we need expert witnesses. And of course, the type of expert might cost different, you know, so we end up having to pay for expert witnesses in cases sometimes, and that may or may not come into play here. All of these things to say there's a lot of variables.
All right.
Enforcement policy, if that's okay.
No. Yeah.
So, the last time I came in to testify on this bill, it was more high level conceptual, like, you know, do we support the bill? Yes, we defer to the Secretary of State's Office on Policy more broadly. And in terms of enforcement, we looked at it more carefully here. And we just want to make sure we have all of the enforcement tools at our disposal that might be needed. And the bill, as it's currently drafted, heavily implies that enforcement would be done through criminal. It's not really clear on that. So our suggestion is just to make it a little clearer that civil investigation and enforcement is possible as well. We defer to Ledge Council on how best to do that, but here are the pieces that we would request. So we don't want to have to conduct a criminal investigation for every alleged violation. There may be inadvertent violations that we think we can dispense of pretty quickly. So having civil investigative tools would be very useful, and also help move things faster. The other piece is that we want to make sure that any information that is provided in the course of an investigation is protected as confidential. If it's a criminal investigation, the Public Records Act has a carve out for criminal investigations. We don't for civil investigations. So it's not clear that if we are doing a civil investigation and we ask for information from a respondent, someone that we think may have violated this law, what they give us, unless it fits under another Public Records Act carve out, we might, if there's a records request, we might have to hand it over without redacting it. So that's the fear, is we don't want to have a chilling effect on responses that we receive in the course of our investigation. We want people to be comfortable giving us everything that we need. So that would be it. We do have, and we have something that does all of this in the campaign finance law. So this would really just be to match that authority. And so we're consistent with our investigations of alleged violations of campaign finance law. here in synthetic media or deceptive media. I don't know what the shorthand is that we're going with, but and then I think it would actually be very useful for the other offenses listed in chapter 35 that are, you know, if somebody votes more than once or somebody shows a photo of their ballot in order to try to influence, things like that that are captured in 35 appear to be, it's not specific. It doesn't say go to criminal court to enforce, but there's possible imprisonment. So it sort of implies that we're in a criminal sphere. And it would be very useful to have the same civil investigatory authority that we have for campaign finance law to do investigations. Because maybe somebody mailed in their ballot and then they forgot they did that and they went and voted. And it's just an inadvertent mistake. And we're able to dispense with that pretty quickly versus somebody trying to deceive or to, you know, somebody trying to upend elections by voting twice to prove they can do it or something like that would be different. So we just want to have the tools at our disposal. And I have sent some proposed language to Lids Council to consider on this vein that would capture that, but they are more experts on how to go about this than me. So I would defer to them on that. And let me just check my notes. And then there's some simple things like changing the words penalties to remedies and conviction to violation that would help make sure that the court would interpret this bill to apply both in criminal and civil investigation context. So
And penalty to remedies, or was the same?
conviction to violation. There's just a few spots where that pops up. So that's it for me. I'm happy to answer questions or talk about it more, but I think I've made the point, so I don't want to waste time.
No, I appreciate that. I appreciate the government efficiency. Any questions? What we have here? So, yeah, we have a couple of committee members absent. So we want to make sure we're having this conversation with the totality of the group. So, I appreciate the input and helping craft it in a way that's more functional for everybody too. So thanks for the time and the focus.
Well,
All right. So Rep. Boyden has been the primary on this, but she's also down in Senate Econ with the cannabis bill because she's the primary on that one. So we were going to chit chat with her after this block of testimony on this bill to see how we keep on this in. So I knew this wasn't going to be an easy conversation. Anything else to discuss right now before we shift over to the dual conversation in 5 minutes? All right, cool. Well, Autumn, take us off for 5 on